we saw recently, I think it was filed on the docket just the other day on the 21st, that Anthony Ricco, who serves as one of the counselors to Sean Combs, moved to withdraw as his counsel. So in thinking about that, I pulled from the docket his motion. And as you would expect, it doesn't give too much detail. And I'll go into that as to why that is, or why I suggest that is. In sum and substance, and then the important part is what he says is, although I have provided Sean Combs with a high level of legal representation expected by the court, under no circumstances can I continue to effectively serve as counsel for Sean Combs, consistent with the ABA, which is the American Bar Association's standards for criminal justice. Then he goes on to add in a separate paragraph that the motion for withdrawal of counsel, if granted, will not result in a delay of the present schedule for the commencement of jury selection and trial, or the present schedules for briefing any of the pretrial motions, and that there will be no lapse in representation of Mr. Combs. Now, so I thought about, what does a court look at? And why does he say so little in moving before the court? Because anytime you're asking the court for relief, and in this case he's asking to be relieved of counsel, you usually have to provide the reasons for doing that. But he speaks about it in broad brushstrokes. And I think the reason why he does that is he has an attorney-client privilege with Sean Combs. So his discussions with his client, the strategy by which he represents him, he can't disclose that to the court, and certainly not on an open public document. So, in an open public filing. So he's got to be careful not to breach the attorney-client privilege, but by the same time, satisfy to the court that he should be relieved as counsel. So the court looks at a few things, and I think the standard in looking at the ABA guidance on it, they first look at whether the withdrawal of counsel would have an adverse effect on the interests of the client, right? Because the client's interests you've got to protect. And as he makes this motion, he's his counsel. As his counsel, he has a fiduciary duty to still represent Sean Combs to the best of his ability, which includes protecting his attorney-client privilege. So some of the things the courts will consider is, what is the timing of it? How close is it to trial? I think the earlier it is in the proceeding, the more opportunity the client would have to get another lawyer. But in this case, there's probably even less prejudice to the client because he has another lawyer. He has Mark Agnifilo, as I guess as his other chief counsel in this case, and his firm. So there's probably less prejudice to the client. I expect this motion to be granted, just on that, or could be granted on that basis of alone, but there's probably more. The trial, I think, is not scheduled to May 5, so being that it's February, there is still time for another lawyer to substitute in for him if Sean Combs desires that to be so. Another thing they'll look at is, does Sean Combs take a position on the application? Is he opposed to it? Does he consent to it? So they'll look for that as well. Does the state have any objection to this? Or in this case, the federal government. They'll look at that sort of stuff. So it'll be interesting to see if Combs takes a formal position on the docket, whether the federal government, meaning the prosecutors, take a position, or whether his co-counsel in the case, Mr. Agnifilo, takes any position. So that remains to be seen. So why, though, would a lawyer do this? Because I think that we go into these representations not anticipating to get out. Right? I think, and especially in a case like this, it's a high-profile case. It's a big case. The stakes are extremely high. You have a client, presumably because of his fame and wealth, is willing to pay you, right? So it's probably not financial. I mean, there is a provision or circumstances which lawyers can move to withdraw as counsel for their clients who can no longer pay them. I don't think that's an overriding factor, and courts in many jurisdictions have held lawyers to stay in cases where they are not getting paid. It is a consideration, but probably not affected here. It's hard to guess when there is so little little in the moving papers, but there has to be some sort of fundamental difference in strategy is what I'm taking from this. I'll rattle off a little bit about the ABA rule and some of the, because it's a non-exhaustive list that a lawyer can utilize in the ABA standards, the ABA guidelines to get out of a case. Again, it touches upon the material adverse effect on the interests of the client, but it looks at such things as the client persisting in a course of action involving the lawyer's services that the lawyer reasonably believes is criminal or fraudulent, right? So lawyers don't want to be used improperly to perpetrate a fraud on the court, because on the one hand, we have a duty of candor to the tribunal. On the other hand, you have a duty to zealously represent your client, and sometimes those two duties can conflict. And if they conflict so much so, you'll move to get out of representation. Now, I don't suggest that happened here. We don't know enough about this application to even begin to guess. And I don't suppose that Sean Combs, if he was to oppose this application, would detail much of that, because then they would get in a back and forth on strategy. Another criteria is, perpetrating a crime or fraud, a client insisting upon taking action that the lawyer considers repugnant or which the lawyer has a fundamental disagreement. This is probably more like it, in my guess, in my estimation, and reading the tea leaves, so to speak. I think about cases in which lawyers serve as co-counsels. And lawyers who handle cases like this are typically very skilled, very experienced, very strong opinions, and having two different counsels from two different firms representing him. It could be a conflict in strategy in which Mr. Ricco is uncomfortable with or doesn't believe in the strategy. And look, a lawyer and a client, when you're taking a case like this to trial, really have to be connected on the strategy and have to have no doubt that the plan that they lay out going ahead, leading up to jury selection in May and throughout that trial, they've got to be, on the same page. So that could be at work here. Sometimes you'll have clients who, and the ABA addresses this, who fail to fulfill an obligation that they're supposed to do, in terms of working with you and providing you information. Probably not the case here, but sometimes the clients lack the diligence to assist their counsel in the trial or the representation of a case. I don't suspect that's the case here. But again, the application says very little, but just my gut is telling me no. The representation, another factor would be the representation will result in an unreasonable financial burden on the lawyer. Again, I don't think that's the case for someone of the fame and wealth of Combs. And then the ABA leaves open for good cause, for other good cause. So it's difficult to capture all the reasons, and sometimes there's just poor communication, or there's client and lawyer who just conflict. As I say, it's got to be a right fit, because when you're in a representation like this, when you're in a representation that's going to go to trial, and the stakes is as high as they are, meaning a lengthy prison sentence, presumably if there was a guilty finding, you got to be on the same page. You got to be working hand in glove, because you're working, essentially 24/7 on a case like this between now and the moment the jury comes back in this case.